The case management conference is in the matter of CF 5077-2021 before His Excellency Justice Nasser and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Khalid Al-Tamimi in association with EKP, and the lead counsel is Scott Hudson. The defendant is represented by Muhammad Al-Jinnaw, advocates and legal consultants, and the legal counsel is Ziad Ahmed Goma, and he will be assisted by co-counsel Maria Mull. Thank you very much.
Thank you. We'll start with the claimant.
Sure, good morning. Your Excellency, I would just like to add that my colleague Arthur Dadles is also online with us this morning. So you were at the obviously case management conference. Now we've only received the defendant's case management information sheet this morning, so I'm frantically having a look through it as we speak. But I would imagine there's not too much at stake between us in terms of case management. The case itself, I think we've summarised the issues between us in the case memorandum, and hopefully that is sufficiently clear for Her Excellency and the court generally. And from a claimant's perspective, the only point we really want to address is on document disclosure. We'll be making an application for one set of documents, and that is all. So I do not see a lengthy document disclosure exercise being required, obviously subject to my colleagues' comments on behalf of the defendants. So I would then like to move to trial relatively quickly. I think we can also discuss here today the potential for a preliminary action on the jurisdiction or the time bar issue raised by the defendants may be suitable for the court to determine that in advance, but equally we are happy to deal with that at the trial itself. So I think that's about all by way of introduction, Your Honour.
Again, please.
I think that's all I have by way of introduction.
Thank you.
Your Excellency, would you like me to come back on some of these points?
Yes, please.
That my friend has referred to. So, dealing with the disclosure, firstly, does the court have our case management information sheet that we sent over this morning? We apologise for the lateness of that document, but that confirms that we will be producing no further documents, and the documents that we will be requesting from the other side will be documents in relation to the loss of rental income, because no evidence has been provided in relation to that yet. In relation to the limitation point, you will see from the pleadings that the defendants pleaded quite extensively their case on limitation to say that effectively the claims are statute barred. Having considered it in detail, it would make sense for that issue just to be determined at trial, because that issue will involve a lot of factual issues, and it would not be proportionate for there to be a preliminary trial on that issue and the exchange of witness statements dealing with that issue. So in my respectful submission, whilst that was heavily pleaded in the defence that it should be dealt with as a preliminary issue, with hindsight, actually, it would be far more prudent for that to be dealt with at trial, and that can easily be dealt with as part of a trial. Another issue for the court today will be one of expert evidence. The defendants will seek expert evidence on two aspects. One, a property expert dealing with the loss of rental income and the overpaid charges aspect of the claim, and also an accounting expert dealing with the unpaid service charge element of the counterclaim, and also the counterclaim for reputational damage to the company, because the court may have seen that in some of the exhibits to the reply, there was exhibited some financial data in relation to the alleged loss that the companies have sustained as a result of the defamation damage to professional reputation. So that goes to the counterclaim. So that may also be an issue that the court will need to determine today.
I think those issues are more of to be determined at trial rather than to be determined in the CMC.
But what I mean is, sorry, my apologies, we will need expert evidence to deal with those points, and we will deal with that obviously today, whether or not permission will be granted for experts on those aspects.
From the court's side, I don't think the court minds if those are technical matters that requires an expert. Yeah.
Yeah.
The claimant has a different view.
I'm just wondering, for efficiency, sake of efficiency, on the property expert, I wonder if how my colleagues would feel about a joint expert there, rather than going into extensive individual expert reports, or perhaps a court-appointed expert.
I'll let my colleague, Mr. Gomar, deal with that point.
Hello. Well, we as the defendants prefer to be working with their own third-party experts. So each party would hire their own experts if that works for the claimant as well. But if the court sees that it is more suitable to have a court-appointed expert, then we will of course oblige.
The court doesn't appoint an expert, so it's either the parties decide on a joint expert, or if the parties could not agree on a joint expert, then each party will have his own expert. But I'd rather the parties have a joint expert to agree on one, so it does not later on confuse the courts with different reports, as the issue is something that can be dealt with in a joint with the joint expert.
Of course, we can try and agree on joint experts because we're proposing two experts, not just one. If we can reach an agreement, let's say within a certain time that the court can identify, then each party can then appoint their own expert, if that is acceptable to the court.
It's acceptable, but I'm not sure if you want a joint expert or you want each party to have his own expert.
What I'm trying to say is we're okay with trying to agree on a joint expert. Okay. If the parties fail to agree on such an expert,
if the parties failed,
yeah,
that's all I mean. Yeah, thank you.
So, Your Excellency, that deals with the property expert. Is Your Excellency content for us to have an accounting expert to deal with the financial losses which we claim as part of our counterclaim?
Financial losses should be supported by evidence. Yes, so if the evidence is, if the expert will gather this evidence and provide it to the courts, then yes, why not?
Okay, thank you. And likewise, the parties will try and agree one, and if they can't, then they'll have their own expert on the issue.
Other than the expert matter, have you decided on the list of issues, or is there any?
We've decided on the list of issues. They are set out at the end of the case memorandum. So I'll take you to the page number. They start on page 003-3. There's quite a number of issues in this case. It's not the most straightforward case, but the parties have been able to agree the issues.
What about the draft case management order?
Yes. In terms of the draft case management order, there is one, but we haven't liaised to deal with relevant dates in terms of that order. The draft order appears at page 6 of the bundle. We've dealt with disclosure, so my learning friend and I can easily insert what's been decided in relation to that. We will then simply now need to go on to deal with witness statements and a date for the exchange of statements. In terms of that, I would suggest perhaps a date of 8 weeks for exchange of statements.
8 weeks from the date of the production of documents, yeah?
Yes.
I'm fine with that.
Then we simply need to do with the direction for expert reports. So again, I think my own friend and I can liaise in terms of, because experts will have to be identified, and then deadlines will have to be agreed in terms of the provision of those reports. So I think that's something that the claimants and the defendants can agree between themselves and then submit to the court if that's agreeable, Your Excellency.
Yeah, but to agree on this one, we should at least set the date so the parties have a deadline to agree and have a deadline to provide those documentation. If we let it without setting a date, then you'll just keep on. You might not have a deadline and keep on arguing here and there, and pulls it for a much longer time. I don't think it's so complicated to be to have 1 year until the trial. I don't think it requires this much of evidence. Yeah.
Shall we say expert reports within 3 weeks of the exchange of evidence?
Yep, that seems reasonable. Dates. Likely to be looking at. I'm just looking at, when would you anticipate that being? You're just using a best guess.
So if we have, well, in terms of the production of the document, so if we have 4 weeks for the production of documents, so say 4 weeks from today, which would take us to the 20th of October, and then exchange of evidence is 8 weeks after that.
That's 3 weeks from today, 20th, yeah?
Yeah.
Yeah, okay. And then 8 weeks after that.
So 8 weeks after that.
Which is into 15th December.
Yeah. So that's the witness statements. And then 3 weeks after that, let's have exchange of the experts' reports. So that will be the 5th of January, but I think we should factor in a bit of extra time over the December period. So perhaps if we say the 19th for the 19th of January for the experts' reports.
So I'm just looking at timetables. I'm going to clash that week, but should be able to make that work.
Okay. In terms of the other directions, then, Your Excellency, we need to insert a date for a progress monitoring date for the progress monitoring information sheet. It makes sense to do that after the experts' reports have been finalised. So why don't we say 14 days after that, Mr. Hutton?
So that would take us to...
shouldn't we make some room for the possibility of a supplementary expert report?
Yes, yes. So we've got the 19th of Jan for exchange of experts reports. So supplemental expert report, shall we say 4 weeks after that?
Okay, 1, 2, 3, so 16 Feb thereabouts, that puts us to.
Yep. And then if we have the progress monitoring date 14 days after that.
Okay.
So what date will that be?
2nd of March.
Okay. And then we just need to list the matter for a pre-trial review.
Yep.
So on the 2nd of March, so why don't we say the 1st of April? Or it can probably be any date after the 2nd of March, can't it?
Can be any date after the 2nd of March, and I don't think well, the parties will require 1 month until the pre-trial.
Yeah.
Maybe
So
two weeks is more than enough.
okay, so after the 2nd of March, then let's just say the 9th of March for the pre-trial review.
And then maybe the trial in April, yes.
Yes. And all the other deadlines are pretty straightforward, but we need to now discuss the trial.
If we set a trial date, all the documents from paragraph 20, which is the trial bundle onwards,
yeah,
will be set like automatically.
Yeah.
Unless the parties will agree on a different date, but it will automatically be set because everything will be filed before trial 2 weeks on the skeleton agreement, a couple of days before the trial. So shall we say a trial in April?
Yeah, that makes sense. I have no unavailability then.
Which date is convenient for the parties?
In terms of the trial estimate, Your Excellency, I don't actually think this is a matter that can be dealt with very quickly. We've got potentially 4 witnesses on our side for the defendants. It's quite complex. You can see there's a number of issues. There's going to be a number of legal submissions that are going to be made. I think realistically, particularly with the experts as well, that this could take 5 days, but I'm in the court's hands as to the time estimate. I know my learned friend suggested a time estimate of a half to 1 day. I mean, it would take me a whole day to read the whole bundle, Your Excellency. So I do think that we need to make sure we build in adequate time for the court to read the matter, to deal with the 4 witnesses. There'll be extensive cross-examination of Mr. Gargash, no doubt. I think 5 days, we may even be pushing it tight with 5 days.
I don't disagree with that. My estimate was on the basis of if there were to be no witnesses. But obviously, we've just seen the information sheet this morning, so obviously 2 experts and 4 witnesses rather changes that. So I think certainly best to set it for 5 days. If we can do it quicker, great, but
yeah,
tentatively 5 days. If it's then the judge will decide how he will run the trial and whether it requires less than that. You'll be done by maybe before that, maybe.
Yeah.
Or it takes 5 days. It depends. So we'll set it like for 5 days tentatively.
Yeah, and it may be that at the PTR, where some issues can be narrowed, or that we'll have a picture actually how long this trial is going to take.
Yes, exactly. But for now, 5 days is okay for the court.
Okay, wonderful. Well, Your Excellency, I believe that deals with all of the issues on the draft order. The legal representatives can finalise the terms of that order and make sure all of the appropriate dates are inserted and then file that with the court.
Yes.
In terms of any other matters, there are no other matters from the defendant's point of view. I'll just check with Mr. Gomar. I believe we've dealt with everything on the behalf of the defendants.
Yeah, agreed.
Anything?
And nothing further from the claimants. Very happy with that timetable.
Yeah, but one in April, you didn't decide on one in April.
I've marked 6th of April.
Okay.
Witness more.
So, well, that's a Thursday. Would we start on a Monday?
Yeah, good call.
So, I mean, it's Easter Monday on the 10th, but would we start on the 10th for 5 days?
10th of April?
Yeah, 10th of April. And that would be until the 14th of April. And if that date needs to be moved or if there's any problems, we can raise that at the PTR.
Yes. Ahmed, we're fine with the 10th of April, yeah?
Yes, Your Excellency. I just checked. It's all right.
Then it's all set. You'll finalize the draft CMC order and to send it to the courts to be reviewed and sealed, yeah?
Yes.
Good.
Anything else from the parties?
Your Excellency, not from my side.
Not from ours.
Thank you.
Thank you.
Wonderful. Thank you, Your Excellency, for your time.
Thank you.
Thank you, Your Honour. Thanks, my colleagues.
Thank you.
Thanks.
And to Hamad. Thank you, Hamad.
Thank you.
Facilitating.